People come to me, they understand that they were either disinherited totally or their share was reduced, and they can typically pinpoint a document that was executed. They may not have the actual physical copy of it, but they are made aware of it, and they understand that they're getting sometimes little or nothing. The question is, what becomes then if they're successful and they go to trial, and that amendment to trust or that trust agreement or that will or the amendment to the will, called a codicil, is thrown out and it's ruled void by a court because of fraud or undue influence or because of what we call lack of testamentary capacity. Typically, the general rule is you go back to the prior trust and the most recent amendment that has not been ruled invalid, or you go back to the most recent will. It gets, in essence, reactivated. In the case where there's never been a prior document, then the laws of intestacy come in, and the laws of intestacy are the statutory laws that tell us who gets what when a person doesn't leave a will. Obviously, if there's been a trust, what we call a pour-over will, leaving everything to the trust, and the trust is no longer in existence, typically you would have an intestacy situation. So it's important to understand, well, if this instrument is thrown out, how does it benefit me, if at all? Sometimes people are frustrated to learn that there's been a series of amendments that disinherited them, but that doesn't necessarily mean that the legal status of things will benefit them, because there may have been a will or a trust which was valid but didn't include them at the time. So it's important to get professional advice to think this through before you expend time, money, and effort simply trying to throw out a document with the end result it may not benefit you.